Hi guys, it's Kathy. I hope you're doing well. So, Best of the Mess, episode 2, is where I go back and I highlight some of the good videos that you might have missed from the past. Episode 2, of course, is a sovereign citizen, which is annoying, frustrating. He doesn't stop, and he's in front of a judge you can only see here on this channel. So, let's go.
Okay. So do you, the charges that you're facing are misdemeanor, one misdemeanor traffic offense and 2 traffic infractions. Those are failure to display or provide proof of insurance, driving under restraint, non-alcohol related restraint, and driving an unregistered vehicle. That's counts 1, 2, and 3. To counts 1, 2, and 3, how do you plead? Guilty or not guilty? Or no contest? I accept no contest pleas all the time. But
objection, Your Honor. Are you practicing law from the bench?
how do you plead, Mr. Lawton? Guilty or not guilty?
I'm innocent.
Okay, I'll enter a not guilty plea. And would you like to set the matter for a jury trial or a trial to the court?
Your Honor, can I ask you a couple questions?
No, I've already said that. You already asked me that. And I said, no, Mr. Lawton, this isn't school. I'm not engaging in, I'm not charging you tuition. I'm not playing any games with you. So no, but you can tell me what kind of trial you would like me to set, and I will expedite and set a trial. And you do have a choice to make. You could choose either a jury trial. That would be the jury commissioner would summons jurors in for any jury trial date, and then you and Mr. Turner can select a jury to hear and try the case, make findings of fact, and determine whether or not the DA can prove the charges. Or you can waive a jury, which I'm not suggesting you do, but you could if you wanted to try your case to the court, and that would be a trial to the court to a judge without a jury.
Your Honor, are you a public servant?
Mr. Lawton, I mean, we kind of talked about giving and getting respect, and I'm doing my best, but I'm not going to sit here and answer questions and engage in your nonsense.
I don't know how I can take you seriously unless you prove that you're a public servant.
I'm trying to take you seriously.
Have you taken an oath of office to the Constitution of the United States of America?
My oath is on file with the,
I'm
well aware.
Can you provide it for me to examine?
I cannot, sir, but it is filed up.
And I fail to see that you have jurisdiction to be addressing me.
And I've addressed the jurisdiction issues. I've tried to make the best record I can at your previous court hearings.
For the record,
stop interrupting, because I'm not interrupting you except when you continually badger me. So I would refer you back to December 26. You ordered a transcript. I made the best record I could, and I cited law about jurisdiction. You want to go back and rehash and replay. I'm not going to do it. I am going to move the case forward. And my job today, what I have to do today, is determine after a pretrial conference, which you and Mr. Turner conferred, which is good, whether you have a disposition. But you don't. That's what he told me, and that's what you're telling me.
Your Honor, you consistently interrupted me. I have questions that I would like to ask.
Okay, so do you want to set a jury trial or a trial to the court?
I have questions I would like to ask. For the record, I did not waive the presentation of the penal bonds. I would like to see the penal bonds and specifically the performance bond.
Mr. Turner, I'm inclined to set a jury trial. Mr. Lawton could always choose to switch it to a trial to the court, and it's easier if he waives a jury, and I'm not suggesting that he should waive a jury. It would be harder for him to then exercise his right to have a jury. So do you have any objection to the court setting a jury trial?
No, the people have no objection to that, Your Honor.
All right. Not guilty, please enter on counts 1, 2, and 3.
Objection.
Jury trial will be scheduled. I'm going to set it. I have 180 days to get the case to trial. Mr. Turner, I'm going to set it way quicker, but...
Are you going to rule on the objection, Your Honor?
Objection is overruled. I'm going to set it...
On what grounds do you overrule that objection?
I have no idea what you're objecting to.
I'm objecting to you putting a plea and practicing law from the bench. I have not put in a plea. I'm innocent.
Yes, and I said pursuant to the rules of procedure. You're not the first gentleman or lady who...
Do you have a contract that obliges me to those rules of procedure? Do you have a claim against me?
I have no contract. with
Do you have a claim against me? You have no contract with me. Do you have a contract with me?
Mr. Turner,
Does anyone in this court have a claim against me?
I mean, I'll stay here. It's,
Does anyone in this court have a claim against me?
I was trying to refer to the rule, but Mr. Lawton thinks if he just speaks over everybody.
Does anyone in this room have a claim against me?
I was trying to refer to,
Let the record show that no one in this room has a claim against me.
if the defendant doesn't want to enter a plea, the court should enter a plea and it should be a not guilty plea.
I request that the honorable judge direct the prosecutor to answer whether there are any more charges.
The charges that are being set for trial are the 3 counts.
I request that the honorable judge direct the prosecutor to provide the assessment of the charges as well as a certified audit trail of all transactions, including vouchers, as well as all disbursement documents and receipts. For the record.
You good? Can I continue? I'm on call this week.
I've made a request. I would like to have the penal bonds presented. I would like to see the performance bond.
I've heard your request and it's respectfully denied. So I respect that you have everything figured out and this is.
Do you have a claim against me, Judge?
So.
For the record, do you have a claim against me? Do you have a claim against me? For the record, do you have a claim against me?
Mr. Turner, I'm looking at May.
Mr. Turner, do you have a claim against me?
Mr. Turner, I'm looking at
Mr. Turner, do you have a claim against me?
Mr. Lawton, stop. You can't do that.
If no one has a valid claim against me, then I instruct the judge to dismiss the charges and eliminate them
And the
with
judge
prejudice.
is denying your motion to dismiss, Mr. Lawton.
Based on what authority?
I would refer you back to all of the authority that I tried to respect.
Has the judge made a judicial determination that I shall be denied my Sixth Amendment guarantees
No,
of due process?
I will appoint an attorney if you would like to fill out an application for
You-
public defense.
May-
Stop. You're just speaking over. You just raised the Sixth Amendment. Do you know what the Sixth Amendment is? If you do, let me answer it. And stop. This is your behavior, Mr. Lawton. I mean, please come back to reality, but stop. And you have to understand.
I do not understand.
Okay, that's fine. You can be out in Planet Lawton or not understanding, and I will try my best, but you asked about the Sixth Amendment. Stop.
Tell me when
Stop.
will you tell me when it's my turn?
Yes. Sixth Amendment is your right to an attorney, and I can appoint an attorney from the public defender's office. I have applications.
Please
If
don't.
you'd like one, I will definitely give you one.
Don't give him one.
But just continuing, because whatever you're referring to, I have to be able to answer your question. So that's the question. If you would like an attorney, I do think you can run things by an attorney, and I can even appoint a lawyer for you. It's not a lawyer of your choice, but it's a lawyer from the public defender's office if you qualify. If you'd like an application, just stop there, tell me, and let me give that to you, or let me have the clerk of court put it up there so you can grab it yourself. So you have that option. If you don't want an attorney, that's all right. You have the right to represent yourself, but you have to understand, as you represent yourself, there's still rules that apply to you. So you're representing yourself. Great. That's good. But I can still enforce rules and set rules, and that's what I'm trying to do. And I'm not going to escalate with you other than like to keep you from like just going off, and I'd like to avoid holding you in contempt. I can respect you
Taser.
as a participant in this court without necessarily agreeing with whatever ideas you think apply to you that don't apply to me or don't apply to anybody else. That's fine. So if I said something disrespectful, which I feel like I just did, I apologize. The planet part. I'm trying to tell you that I'm trying to just get through this thing, which is what I told you on December 26th, the day after Christmas, and I told you in February. What I have to do today is just navigate a pretrial conference, and you guys had it. Good work. You haven't settled the case, fine. The next step is for me to check in with you. You don't want to enter a plea. Okay. I heard you. You said that. I believe the rule of procedure does I can't enter a guilty plea for you, and I can't enter a no contest plea. So my only other choice is a not guilty plea. So that's just like anybody. I entered a not guilty plea, and now I need to set a trial. You haven't picked, so I'm setting a jury trial. You can always shift gears, but I'm starting with the jury trial. If you want an attorney of your own, you do have that right, and I can appoint a lawyer. Now, the next issue is if you want discovery or reports or anything at all, I am ordering Mr. Turner's office, the DA, to give that to you upon request. You do have to make a request, but then they have to provide it for you. District attorney has to file endorsements of witnesses. They have filed them on December 18. District attorney has another deadline to meet, which is 35 days prior to trial. And that's what I was trying to advise the district attorney. I'm setting a trial date quickly. It's well within speedy trial, but please don't lose track of the 35-day prior to trial deadline. There's a number of other trials that are probably older than your case, so yours may not go. But I am going to get it set up for a trial track. So do you accept, does the district attorney accept May 16 at 8 a.m.?
Yes, Your Honor.
Okay, Mr. Lawton, that's just over 60 days. It has to be brought to trial within 180. So there's a lot of time, but I'm going to set it first, May 16th at 8 a.m.
Objection.
Okay, your objection is noted. Do you have any specific objection to that day? It's a Thursday. Or is this like a general objection to the trial?
It's an objection to moving forward. I have some questions that I would like to have asked before I answer those types of questions. I understand you're trying to move the trial forward or move the case forward or whatever you will. It feels to me like you're rushing me to judgment, and I don't appreciate that. I have some questions that I would like to answer. They're very sincere questions about the nature and cause of the claim according to my Sixth Amendment right. I still, after my third special visitation to this court, have not been informed of the nature and cause of this action, and jurisdiction can be challenged at any time. I have some very simple, straightforward, and important questions that I would like to have answered before any of these things can move forward, before I will consent to any of these things. And first off, I'm here under duress, coercion, and threat of violence from the very beginning. From the very beginning, I've been misaddressed. I've entered a new document into the court file. Have you seen it? Have you read it? Would you like me to read it into the record? I would love to read it into the record.
Objection, hearsay.
The clerk of court took filings from you on March 6 and March 11, so those are preserved.
I would like to read it in the record so we can discuss the points.
I'm not going to have a discussion with you. You don't have the right to read, but I will tell you, if it's the document you filed on March 6 or March 11, the clerk of court took it and has preserved it for the record. And so certainly if you want to follow up with anything else, you can, but that's not what I'm doing today.
It's in the shredder.
Anything. Okay, so I've preserved your objection to the trial generally, but I want to make sure May 16 is a Thursday at 8 a.m. So if there's anything specific about that, for example, you have a medical appointment. That would be what I'm asking if there's a more specific objection to Thursday, May 16th.
I object to all days ending with Y.
That's going to be the first setting of the trial. But I have heard your objection about me setting a trial. All right.
The reason I keep speaking up is because I don't wish for my silence to be interpreted as acquiescence.
You haven't acquiesced to anything.
Wonderful. I want, for the record, I reject any presumption of contract or any presumed degradation of status by crossing the bar or participating in this setting. As I mentioned, I'm here as the sole survivorship interest in the Nicholas Reed Lawton estate. And I resent and object to the prosecutor addressing me and filing charges against my estate. And I would like to see his bond immediately. I don't know how he's even addressing the court without putting in a bond. And I think it's a perfectly reasonable thing for him to come to court with the bond. Why doesn't he have it right now? Why is it not in my hand? I would like it in my hand right now.
Your Honor, I'm not aware that that's even a thing.
And if there's not a bond in this case, then I instruct you to dismiss.
Yeah, I've heard you make that request a couple of times and I've respectfully told you that I'm not going to grant your request for dismissal.
May I see the penal bonds? May I see the bid bond?
Kinky.
At some point, I need to just
May I see the bid
call
bond?
it what it is, which is, you know,
Is there a bid bond in this case?
it's like people can ask for something nonsensical.
Will you
and that's
answer my
essentially
question?
what's
If,
going on.
if there's not, it should be easy to
if you
answer.
have
If there
any-
is, it should be easy to answer. Is there a bid bond in this case?
Does the district attorney have any other issues with regard to trial management, trial scheduling, motion issues, or discovery?
Your Honor, I don't believe we do. And in fact, I believe we made discovery available to Mr. Lawton previously. I don't know if he did have an opportunity to pick it up or or if it was, or if he received it via mail, but I think we did make an effort to deliver that to him.
Okay, yes, that's what I keep reiterating, that any accused is entitled to receive discovery, just with the simplest of request. Any sort of pretrial motions that need to be set for a hearing?
Your Honor, I don't believe so. Not at the moment.
Mr. Lawton, any motions that you'd like to have set for a hearing or other?
Objection.
To me asking if you have any motions to be set?
My name is not Mr. Lawton. I'm here by special visitation as a living man. My name is Nicholas Reed. And I object to being addressed as anything else.
Your objection is noted for the record. Is there any other motions you want me to set for hearing or anything else you want to do along those lines?
I have some questions. I still wish to challenge the prosecutor standing to invoke the jurisdiction of the court, the nature and cause of the claim.
All right. Your
May I-
objection of jurisdiction is noted, and
Your Honor, I'm confused. Maybe you can help to clarify.
I can't.
Is-
That's
is-
not my job.
I am not asking.
To advise you again, as I have in the past, you have an active warrant from Fremont County. 2021 T299 is an active warrant from Fremont County, and so I just advise you again that you should consider remanding to either the court that issued the warrant or the county jail. It looks like you did write a letter to Judge Roback, and she responded confirming the defendant is on warrant status. The court takes no action until the defendant is back within the jurisdiction of the court. So I just putting you on notice of that and trying to let you know again. Otherwise, the case is set for a jury trial May 16th
Objection.
at 8 a.m. And that concludes the
Objection.
proceedings today.
Your Honor, I have more questions.
And as I said, Mr. Lawton, I'm not here to answer your questions. So court goes off record at
Your Honor,
You are-
my understanding, you have a constitutional duty to provide me with the nature and cause of the claim according to your Sixth Amendment, your Sixth Amendment obligation. May I see your oath of office?
off record at 4:11 and